excluding the community around the Ndansane area. So the aggravating factors, just to conclude, that the court must consider the degree of premeditation, the lack of remorse, the inadequacy of Ms. Thompson's evidence. She spent 5 hours assessing the accused, and I'm not talking about 5 consecutive hours that she can at least get an idea who the person is she's dealing with. She speaks about an hour and a half here, an hour there, and 2 hours there, on different dates, different times. She was just basically there to do a job, just to compile a report for the purposes of these proceedings, but did not compile it to assist this court to come to the correct decision. She was biased in her assessment. Basically, she was employed by the accused to come and bring that report because she was paid for it. His absence of remorse, insight and accountability, until today he still doesn't see what he did, what danger it posed, and what its consequences could have been. His position as a public leader and a role model to the young and to society. The fact that he's a lawmaker, breaking the law. The fact that 2 firearms were used and live ammunition were fired. Not once, like in Oscar Pretorius, not twice, but multiple times. The degree of premeditation involved and his deliberate conduct puts him in the category for 7 to 15 years. If the court imposes a custodial sentence, it will satisfy the principles as set out in State versus Zinn. And the court will do its constitutional mandate of equal treatment before the law, and will serve the legitimate and pressing interest of a society that has the right to expect that its leaders and lawmakers be subjected and to obey the same law that they are elected to uphold. That's my submission, unless there's anything else the court wants to hear me on.
Thank you.
Thank you.
Be with you now. I just want to get the charge sheet and endorsement. Be with you now. Adv Ngcukaythobi. Thank you.
All right, my learned friend has one more issue.
Just one issue that I also need to put on record, that Mr. Snyman the state considered that it did not prove its case beyond reasonable doubt, that it did not, it was unable to show in the video or see in the video that it was Mr. Snyman that gave the firearm to Mr. Malema. That part was inconclusive, and that's what's the reason why Mr. Snyman was acquitted. Thank you.
Your Worship, thank you. I have 5 points to reply to.
Yes.
The first one is the firearm issue. It is an important issue, although my learned friend tries to make light of it, because it's all regulated by statute. Firstly, your ladyship wanted to know what the source of the evidence is. The first part is page 21 of the report by Ms. Thompson at paragraph 50.4, where she says, it appears that the accused received the rifle ready to shoot from someone authorized to possess and handle it, most likely from the Tactical Security Services, who provided security services at the celebration event. However, no individual was convicted of supplying or transferring the firearm to the accused, and this is the crucial part. And the rifle was shown in court was returned to Tactical Security Services before judgment was delivered in this trial. That's the first part of the source. Then, if your ladyship then goes to the transcript of the evidence of Ms. Thompson at page 35, at line 8. She says, however, no individual was convicted of supply or transferring the firearm to the accused, and the rifle that was shown in court was returned to Tactical Security Services before judgment was delivered. That is because the forfeiture of firearms that are used in the commission of offences regulated by the Criminal Procedure Act. My learned friend has already referred us to section 30 of the Criminal Procedure Act, but your ladyship will discover that section 30 is actually inapplicable in the current circumstances, because it deals with disposal by police officials of articles after seizure. It doesn't deal with articles that are part and parcel of the criminal proceedings themselves. Similarly, section 31, which is another section that was relied upon by my learned friend, refers to disposal of articles where no criminal proceedings are instituted or where the article is not required for criminal proceedings. So we know in relation to the first requirement that criminal proceedings were instituted, and in relation to the second requirement, the firearm was required for criminal proceedings. So it also does not apply. What does apply are the two sections that were not referred to by my learned friend, which is section 34 of the Criminal Procedure Act. That section is headed Disposal of Articles After Commencement of Criminal Proceedings, which is where we are. The criminal proceedings have commenced. The article is a piece of the evidence that will be used to prove the offense. It says the judge or judicial officer presiding at criminal proceedings shall, at the conclusion of such proceedings, but subject to the provisions of this Act or any other law under which any matter shall or may be forfeited, make an order that any article referred to in section 33 be returned to the person from whom it was seized, if such person may lawfully possess such article. So it is up to your ladyship to make an order that an item that was part and parcel of the commission of the offense, which was used in the criminal proceedings, may be returned. It is not up to the state. Why that is important is also section 35, which is another section that was not relied upon by the state. That deals with the forfeiture. So your ladyship will know under section 34 you may order the item to be returned, but under section 35 you may order the item forfeited to the state as well, because under section 35 subsection 1 it says a court which convicts an accused of any offense may, without notice to any person, declare any person, instrument, or other article by means whereof the offense in question was committed, or which was used in the commission of an offense, or if such conviction is in respect of an offense referred to in Part 1 of Schedule 2, any vehicle, container, or any other article which was used for the purposes of or in connection with the commission of the offense in question, or for the conveyance or removal of the stolen property, and which was seized, and we know this firearm was seized under the provisions of this Act, forfeited to the state. So what happened here is that the prosecutors on their own showing agreed with one of the accused persons to take the firearm before judgment was given. That raises profound questions of the propriety of the conduct of the prosecutors. They themselves admit that they sent an email, although they put a different slant to that email. The slant they put is that they said, if you are acquitted, you may come and collect the firearm. Whereas the provision, section 34, says the judge or the magistrate, whoever is presiding, may make that order. But it raises profound questions, my lady, with the greatest of respect. The first is, how does the accused know that he must come and collect the firearm? But it also raises another question, which is, how did the state take this matter as serious if they were already making arrangements prior to judgment about the return of the firearm? They say that there were emails that were exchanged, but those emails have not been produced. And that is in the context where a witness has given evidence. It is correct, as my learned friend points out, that the witness says, my source of the evidence, you see that in paragraph 5.1 of the report, my source is Mr. Malema. But if they have this email chain, you would expect that on the day the witness gives evidence, they put it to her. But they don't. And then they try to get that evidence introduced in argument, which your ladyship can just dismiss without more. So we submit, therefore, your ladyship, that there is a potential irregularity which flows from the non-compliance with Section 34 of the Criminal Procedure Act and the non-compliance potentially with Section 35 of the Criminal Procedure Act. But we say it also raises really profound questions about how this knowledge occurred prior to the delivery of the judgment. We leave it there, we take it no further, but we say it does raise deeper questions that require interrogation. But it does show that even on the state's showing, they did not regard the offense to be serious. Why do you return the instrument of the commission of the offense prior to the delivery of the judgment? Why? So that's in relation to question 1, which is the return of the firearm. We say it's relevant to sentencing because it shows that the state did not treat this as serious, but it's also relevant to a larger question about the impropriety of the conduct of the state. The second question I want to address then is to look closely at why does the state say Mr. Malema should go to jail? This is clearer because the main heads of argument are actually quite confusing about why they say that he should go to jail. It's clarified in the supplementary heads because there they identify 4 reasons, and I want to address each and every one of them now. The first one is this idea of premeditation, that the offense in question was premeditated. But it seems that they actually misread the evidence because the planning that Mr. Malema talks about, if you look at the supplementary heads of argument, the leadership will find this at paragraph 7 of the state's heads of argument. In the italicized portion, which has inverted commas at the bottom of the page, where Mr. Malema is quoted as having said everything was perfect and calculated and designed to be the way it was done. He is not talking about planning the commission of an offense, he's talking about planning the celebration, the celebratory event, even on what they have quoted here. So that's why it's important never to read words out of context. What they have done is that they have planted words in their heads of argument, and then they've imputed a meaning that those words were never designed to achieve. And we say, in addition to the distortion of what the actual evidence was, the evidence was not planning the offense, the evidence was about planning the event. That actually cases of planning and premeditation of offenses usually show an element of a design. How are we going to rob a shop? How are we going to rob a bank? What they don't show is the spontaneity of a firearm being given to a person, one shot, which is on the evidence, and your ladyship will see from our heads of argument. The second conviction is about one bullet. It's one bullet, not the 22 bullets, one bullet. So ordinary cases of premeditation do not have that element, because what you find is that a group of criminals sit and they plot how to execute an offense. This is not where someone gets a firearm, they shoot, they retain the firearm, and that's the end of the story. So it's even inconsistent with a classic instance of premeditation. And bearing in mind, my lady, that the state says, if you look closely at what they say in paragraph 7, the most significant aggravating feature. In other words, they hinge their case on the premeditation. But if the basis of the premeditation is a misconstrual of the evidence, your ladyship can discard that without more. So that's item 2. So we say your ladyship can safely discard that because they've misconstrued the facts. And in any event, they overlook the fact that we're talking about one bullet. The second reason why they say Mr. Malema should go to prison is because they say it was 2 firearms. But we don't understand. They say 2 firearms, 22 live rounds, and 20,000 people within a community. We don't understand why they say that. If your ladyship goes to our heads of argument, we start off by summarizing what the actual findings were, not what the state wishes the findings were, but what the court said the findings were. And the important ones is 1.2, unlawful possession of ammunition in contravention of Section 90 of the Firearms Control Act, to wit. Now those words, to wit, usually mean in that. In other words, their point is to constrain the factual basis of the finding, not to expand it. A .223 Remington bullet, one bullet, without holding its license, permit, dealer's license, manufacturer's license, gunsmith license, import or export, or in transit license or other authorization. 1.3, unlawful discharge. But that's the unlawful discharge of the one bullet that he was in possession of, referred to in the second conviction. So we have the same problem here, my lady, with the greatest of respect, that the findings are distorted. It's a narrative building. Yes, and my learned friend also points me to even the first finding is unlawful possession of a firearm. Not the firearms, a firearm, one bullet. So we've got a problem here that when you look at the second reason why they say Mr. Malema should go to prison, there is a disjuncture between what the state says and what the court found. And then you can't do this. You can't send somebody to prison for reasons that the judge did not find him guilty of. So this is the problem now with item 2. 2 firearms, 22 live rounds before 20,000 people. So in other words, the correct postulation is one bullet in a stadium of 20,000 people. One. That's the correct postulation. And then ask yourself, in those circumstances, should I send this man to prison? And it's so absurd that they say, don't only send him to prison, send him to prison for 15 years. It's like a game that they're playing. It's a game to inflame the passions of the public. Then the next reason why they say Mr. Malema should go to jail is, if you look at their supplementary heads, because he's a public leader in their own way, Now here, my lady, I sympathize with the state that we say, well, people that are holding positions of society should take responsibility and they should be good examples. But it's precisely the same reason that Ms. Thompson says you should look at Mr. Malema differently. And your ladyship, I want to remind your ladyship, when we were here during the evidence of Ms. Thompson, when your ladyship commented, and they said, what's so special about him? The state says he's special. When we now say today, treat him through the prism of Section 9, everyone is equal before the law. So in other words, my lady, what you have is that for the state that chops and changes its case, depending on what it wants to achieve at a particular point in time. Today, they're trying to expand the realm of penal activity as expansive as possible. And then they say, okay, look at the fact that he's a parliamentary. But when the witness was here, they said, no, his parliamentary position is irrelevant. He must be treated like everybody else. But a court cannot follow that unprincipled approach. Your ladyship must apply Section 9 of the Constitution, which says everyone is equal before the law. We obviously take into account that Mr. Malema must bear responsibility as a leader in society. We don't run away from that. But it's precisely because of that factor that we say, if you actually look at the fact that he has been criminally charged, it's a public trial that he's been undergoing. The fact that since the day of the charge, there is not even an allegation that he has ever attempted anything to do with the possession of a firearm. The fact that even before he was charged with these offenses, there is not an inkling that Mr. Malema had a propensity to possess firearms or to discharge them openly and publicly, recklessly, as the state tries to argue today. And the fact that the public trial itself has a shaming effect on the public representative. It has a shaming effect on the public representative because already people are saying, oh, well, why should he not lose his seat in Parliament? Why should he not lose his seat in the JSC? And the fact that, my ladies, the fourth part of it is that we are not asking for a no punishment. We are simply asking for a non-custodial punishment. And no one can sensibly say that other forms of punishment do not constitute punishment, which is the zero-sum argument posited by the state. There is only one punishment as far as they're concerned, it's custodial. So what we say, my ladies, is that you have a range of penal options that would reflect the society's disapproval of, I would say, public misconduct by public representatives. And the custodial penalty, in fact, achieves the opposite. So we say that ultimately it's a neutral fact that he's a public leader and a role model. The next one that they say you should actually send him to prison for is that he has no remorse. But they themselves say in Hewitt versus S, absence of remorse is not an aggravating factor. The state says that in paragraph 17 of the Adv Ngcukaythobi. It's not an aggravating factor. But my lady, there is a fundamental legal problem with the argument. If an accused says, after conviction, I disagree with the magistrate, I'm going to appeal because the magistrate has wrongly found me guilty. The state says, infer from that he's not remorseful. It's absurd because even under Section 35 of the Constitution, he has a right to an appeal. And the right to an appeal is based on a view held by an accused, wrongly or what, that the magistrate is wrong. You cannot say, I am going to punish this accused because he articulated a view that I'm wrong. That is just an abuse of judicial authority. So he is entitled to say, I respectfully think that the judge got it wrong, and I'm going to appeal. The judges on appeal may say to him, Mr. Malema, it is you who's wrong, and not the judge. But in expressing a penalty, a judge cannot say, I'm going to punish you more because you said it's absence of remorse just because you say, I do not agree. And I want to take this point further about the absence of remorse. They say, Mr. Malema has said these proceedings are an abuse of resources and the prosecutors are incompetent. That's what they say in their heads of finding. But my lady, if the prosecutor takes personal an accusation that they are incompetent, you know what happens? They violate Section 179 of the Constitution, which says that they must prosecute without fear without favor, without prejudice. In other words, they must be prepared to accept the accusations and the criticisms from accused persons. They must not say, this accused person said that we are incompetent and therefore he must be punished more. Because that is not how the law works. The law works on a dispassionate basis. Whether someone has a loud mouth or that doesn't have a loud mouth, they must still be treated in accordance with retributive, which is fine for sentencing. Therefore, he must be punished, because it's not retributive, which is fine for sentencing, but it's vindictive, which is in conflict with the Constitution. So we say your ladyship cannot give an order that would be in violation of Section 179 of the Constitution. Then they say, this is now paragraph 18, where in B they said, it described the proceedings as an abuse of the NPA resources and an incompetent prosecutor, and that Afriforum was to be blamed. Again, we all know the history of this case, my lady. We don't have to repeat it. It is Afriforum that has been behind the prosecution of Mr. Malema.
No, sorry, no. Advocate Ngcukaythobi, that is not a reason for mitigation here. We are dealing with mitigation, and I am indulging the defense.
My lady, it's 18B of their heads of argument. Look at 18B of
On
this
which
case.
one? Supplementary or the
yes,
first
yes.
one? 18B.
B. So there they say, Mr. Malema complains of a political vendetta by Afriforum. That's the point I'm addressing. Leadership doesn't want me to refer to Afriforum, that's fine.
No. Sorry, Advocate Ngcukaythobi. I'm just quickly reading what you are referring me to before saying that I don't want you to say it. Let me just read the paragraph.
Thank you, madam.
Okay. Advocate Ngcukaythobi, I've got that. I hear you. This is what the narrative of your client's evidence was during his evidence in chief and cross-examination, which the state is quoting here, according to my understanding. But you may proceed. I'm noting what you are saying.
My lady, it is the state that says that Mr. Malema lacks remorse because he has blamed Afriforum. I'm simply explaining.
And the Holy Spirit, including
I'm not dealing with the Holy Spirit, I'm dealing with Afriforum.
Please leave. I've spoken.